going to be discussing in detail about it. So without taking much of the time, now I'll invite today's esteemed faculty, Advocate Madhukar Dalvi, to share some light on the topic. Madhukar, it's all yours.
Thank you so much, Mr. Rishikesh Vyas, for the introduction, and thank you so much for giving me this opportunity to come here and to address on certain aspects of criminal law. As lawyers, we often work on our matters whenever we conduct those matters before the court of law. And at that point of time, we have a completely different way and approach towards working on a matter. But when it comes to addressing a seminar, that time we need to ourselves learn so many aspects which otherwise we may not venture into in the court of law. So this is an attempt which I'm going to be making right now in order to uh, discuss certain aspects of the law of evidence as per the Indian Evidence Act, and also in view of certain provisions which have been incorporated by the Information Technology Act. The kind of impact the technology has on the daily life, on the judicial proceeding, is something which I would like to enlighten all of you on. To start with, I would like to take you all to the definition of document under the Indian Evidence Act. The term document is defined under Section 3 of the Indian Evidence Act. What it says is, document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Further, the Indian Evidence Act also defines the term evidence under the same section, that is Section 3, and it says evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence, and all documents, including electronic records, produced for the inspection of the court. Such documents are called documentary evidence. So basically, there are two types of evidence. One is oral evidence and one is documentary evidence. Now, in this session, I will be talking about the documentary evidence, which is more discussed and enlisted in Chapter 5 of the Indian Evidence Act. This particular chapter deals specifically with documentary evidence, about how documentary evidence is to be led. What are the ways of proving a document before a court of law? Document is undoubtedly a very crucial aspect in any trial. You come across so many cases pertaining to economic fraud, corporate crime, and other various criminal offenses in which there are different types of documents which are involved, which form the basis of the case, which form the basis of the evidence that has to be led as per the procedure prescribed under the Indian Evidence Act. Now, under Chapter 5 of the Indian Evidence Act, it starts with Section 61, which talks about proof of contents of documents. The contents of documents may be proved either by primary or by secondary evidence. So these are the two ways of proving the contents of a document. Whenever we are producing any document in a court of law, that has to be proved either by leading primary evidence or by leading secondary evidence. Now, what is primary evidence? That is defined under Section 62 of the Indian Evidence Act. And it says primary evidence means the document itself produced for inspection of the court. Now, Section 63 talks about secondary evidence. Secondary evidence means and includes certified copies given under the provisions hereinafter contained, copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy, and copies compared with such copies, copies made from or compared with the original, counterparts of documents as against the parties who did not execute them, oral accounts of the content of a document given by some person who has himself seen it. So these are the two methods of proving a document. One is by primary evidence, second is by secondary evidence. Now section 64 says that documents must be proved by primary evidence except in cases hereinafter mentioned. So when primary evidence cannot be led in the court of law to prove a particular document, it is only then that secondary evidence can be led in order to prove that document. And that procedure is explained under Section 65 of the Evidence Act. Section 65 of the Evidence Act deals with cases in which secondary evidence related to documents may be given. Secondary evidence may be given of the existence, condition, or content of a document in the following cases. So they have specified the cases in which secondary evidence can be given. Otherwise, the basic rule is that it is only primary evidence that has to be adduced in order to prove the document. Now, these cases where which contemplate secondary evidence are as under, which are described in section 65 itself. Section 65A, when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process of the court, or of any person legally bound to produce it, and when, after the notice mentioned in section 66, such person does not produce it. This is one eventuality. Second condition, when the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. C, when the original has been destroyed or lost, or when the party offering evidence of its content cannot for any other reason not arising from his own default or neglect produce it in reasonable time. D, when the original is of such a nature as not to be easily movable. And E, when the original is a public document within the meaning of section 74. F, when the original is a document of which a certified copy is permitted by this act or by any other law in force in India to be given in evidence. And G, when the original consists of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole selection. Now, these are the cases in which secondary evidence can be permitted to be given in the court of law. Now, these two aspects, that is primary evidence and secondary evidence, are so important and significant in a criminal court of law. There are a lot of principles, there are a lot of positions which have been discussed and explained by various courts of law coming to this particular aspect. What it says is there are some basic propositions which I would like to elaborate on this. These propositions are coming out of certain judgments of the various high courts and of the Honorable Supreme Court as well, while discussing with the aspect of documentary evidence. What it says is admission of document amounts to admission of content but not its truth. So whenever a document is produced before a court of law, be it an original document which is produced, the admission of that document would only amount to admission of the content and not its truth. Under section 61, the contents are to be proved either by primary or secondary evidence. And under section 62, primary evidence means the document itself produced for inspection of court. Even on such proof, even by producing the original document in the court is not bound to accept the content unless it is satisfied about the truth of the matter stated. Once a document is marked on admission, content thereof also is treated to be admitted. In the daily parlance before the court of law, whenever we produce any document in the court, that document is always marked as an exhibit. Now, marking the document as an exhibit will only prove the contents of that document. and it does not prove the truth, genuineness, and veracity of that document. Truth of correctness is to be ascertained from the evidence. A party admitting a document has right to explain that though the document contains such a statement, it is not correct. So thus, merely by marking a document or exhibiting a document in the court, that document cannot be said to be proved. It is open for the other party to challenge the correctness and the truth of that document. And it is also open for the court to look into the genuineness and veracity of the document and then decide whether that document can be considered against the accused in the course of trial and used as an evidence against you. Similarly, content of the document is to be proved by admissible evidence. Marking of exhibition would not mean content also proved. These are certain guidelines which have been reiterated by various judgments of the Supreme Court, including one of the landmark judgments of Badrinath Banerjee versus Hiten Dalal, 1994, for Bombay Crime Reporters 237. The ratio of that judgment and the observation with regard to exhibiting of the document and proof of the document is that marking of exhibition would not mean content, proving the contents of the document. There is another judgment which is very much relevant on this particular aspect. State Taraji Khinchan versus Yelamarti Satyam, the 1971 Supreme Court judgment, which also says mere marking of exhibit cannot be the proof of document. Now, we come across cases where certain documents are procured in an illegal manner. What is the scenario when these documents are procured in an illegal manner and are produced before the court of law? Can these documents be admissible in evidence? On this, there is a judgment of the Honorable Supreme Court, Meghraj Patodia versus R.K. Bisla, AIR 1971, Supreme Court 1295. It says that illegal procurement of a document is admissible. So ultimately, the court has to consider the genuineness and authenticity of that document and then decide whether that document can be treated as admissible in evidence and whether it can be relied for the purpose of deciding the matter. Now, similarly, when primary evidence is not admissible, when primary evidence is not available, that time a document can be proved by leading secondary evidence. Production of certified copies under the provisions of Section 63 is a means of leading secondary evidence. Secondary evidence can obviously be led only of what the document states and not as to whether what the document states is true. Again, secondary evidence will also prove the contents of the document and not the truth of the document. Now, Section 61 and Section 62, if we read both these sections together, show that the contents of a document must primarily be proved by the production of the document itself for the inspection of the court. The truth of the contents of the document, given prima facie, cannot be proved by merely producing the document for the inspection of the court. What it states can be so established. Executant must be examined or his affidavit has to be filed. It is only then that the truth of the document can be proved before the court of law. And whenever the witness, who is the executant of the document, is examined by way of examination in chief, the prosecution has to lead the witness in the box and examine him and make him to depose in the court. And the other side, that is the accused, should be given a due opportunity to cross-examine that witness. And then only that document, the truth of that document can be ascertained by the court of law, depending on various other facts and circumstances. Sometimes the document becomes a sufficient proof of evidence. Sometimes the document can be used as a corroborative piece of evidence. When a document is produced in the court and is not proved by leading any evidence, by not examining any witness. We come across several cases in a criminal trial where there are certain documents which are filed in the charge sheet, which are annexed to the charge sheet and which are filed in the court. Now, the prosecution may not examine a particular witness in order to prove the content and the truth of that particular document. Now, this is a serious infirmity, but it does not go to the root of the case and it does not shaken the foundation of the prosecution case. It is at the most a procedural infirmity which can be rectified. So, the truth or correctness of contents of documents is to be ascertained from evidence before which is led before the court. Mere marking exhibit does not dispense with its proof. This has been held again by the Honorable Supreme Court in the case of Soraji Kenton versus Yalamurthy Satyam in 1971 AIR. As soon as the execution of the document is proved and the contents of the document are proved by examining a particular witness who has executed the document, that document is deemed to be proved before the court of law. Proof of document and evidentiary value are two distinct and different factors. The Evidence Act requires first the production of documents in original. If original document is not available, then secondary evidence may be given. This is to prove that the document states. Upon this, the document becomes admissible except where it is signed or handwritten wholly or in part. In such a case, second requirement under section 67 that the signature and handwriting must be proved. Writer of document is required to depose to the truth of its content. Even photographs which are produced in a court can be proved by examining person who took photographs or party who relies on photographs at whose instance photographs were taken. Coming to the aspect of newspaper reports, whether a newspaper report can be proved in a court of law and what is the position of law, what is the how does the court appreciate a newspaper report which is filed during the course of trial. This particular aspect has been discussed by the Honorable Supreme Court in the case of Lakshmi Raj Shetty versus State of Tamil Nadu, 1988 3 SCC 319, and they considered the question of admissibility of the news items appearing in a press report in the newspaper. And the Honorable Supreme Court opined, I am quoting this particular phrase from the judgment, we cannot take the judicial notice of the facts stated in a news item being in the nature of hearsay secondary evidence unless proved by evidence. A report in a newspaper is only hearsay evidence. A newspaper is not one of the documents referred to in section 78(2) of the Evidence Act 1872, which an allegation of fact can be proved. The presumption of genuineness attached under section 81 of the Evidence Act to a newspaper report cannot be treated as proof of the facts reported therein. So it's now a well settled position of law that a statement of fact contained in a newspaper is merely hearsay and therefore inadmissible in evidence in the absence of the maker of that statement appearing in court and deposing to have perceived the fact reported. This is the manner in which a news report has to be proved before the court of law. Now coming to section 63 of the Evidence Act. The opening words of section 63 indicate that it is not exhaustive. Section 63 mentions 5 kinds of secondary evidence. Clause 1, Clause 2, and Clause 3 of the section refers to copies of documents. Clause 4 refers to counterparts of documents. And Clause 5 refers to oral accounts of the content of documents. These are the 5 clauses under section 63 which make leading of secondary evidence possible before the court of law. Now I come to the main aspects of this particular session. I I wanted to first briefly discuss these provisions, which are very important under the Indian Evidence Act, in order to understand the concepts of documents, evidence, primary evidence, and secondary evidence. And now coming to the main issue before us, the electronic evidence. Because today in this current era, because of the advancement in the technology, everything has become electronic and digital. And in court, we often come across and we often encounter such situations where certain computer related messages, emails, recorded conversations, videos, CCTV footages, call records, all these aspects are adduced in evidence before the court. And that time the court is always confronted with a major task of deciding the admissibility, the veracity, and the genuineness and the quality of this of the electronic evidence which is produced before the court. So to start with, I would like to discuss about tape recorded conversation and the admissibility of a tape recorded conversation. If a statement, the, the basic premise over here is that if a statement is relevant, an accurate tape record of the statement is also relevant and admissible. The time and place and accuracy of the recording must be proved by a competent witness, and the voices must be properly identified. One of the features of magnetic tape recording is the ability to erase and reuse the recording medium. Because of this facility of erasure and reuse, the evidence must be received with caution. The court must be satisfied beyond reasonable doubt that the record has not been tampered with. This particular these particular findings was held by the Honorable Supreme Court in the case of Yusuf Ismail Nagri versus State of Maharashtra, AIR 1968-147. In that case, the facts were such that one clerk of a municipal office was offered a bribe. When he was offered a bribe, he went and reported the same to the concerned police station, and then they laid a trap, and the person who had offered the bribe was called to the residence of this one Mr. Nagri, who was a municipal clerk. And in that house, the police secretly kept a tape recorder. And when that accused walked in the house, the entire thing was the conversation was recorded by the tape recorder. And that tape recorder, that tape, was produced before the court of law. And during the trial, the informant was examined and he deposed exactly the facts and circumstances of the case. And then the tape was played in the court, and the tape corroborated with the version given by this witness. And the court considered that tape and finally convicted the accused in that matter. Tape recorded conversation is admissible when it satisfies six conditions, namely, identity of speaker is not disputed. Second, cassette was kept in safe custody. Third, voice was clearly laudable. Fourth, accuracy duly proved. Fifth, it is relevant. And sixth, no part of the cassette is broken. Now, all these conditions are required to be in existence before a tape recorded conversation is considered and relied by the court of law in deciding a matter. In order to ensure that no prejudice is caused to the case, and as a matter of caution, because there is a possibility of there being some manipulation and concoction, it has been held that tape recorded conversation can only be relied as corroborated evidence and not a proper evidence, and cannot be relied by the case of Mahabir Prasad Verma versus Dr. Surendra Kaur, AIR 1982, Supreme Court 1043, where out of abundant caution, they held in that particular case, depending on the facts and circumstances of that case, that a tape recorded conversation can at the most be relied as a corroborative piece of evidence, not like a direct or a proper piece of evidence on the basis of which the entire case of prosecution can be based or relied upon. Ventriloquism is not very uncommon, and before carefully guard himself against all this possible tampering and manufacturing, and should look for independent corroboration and intrinsic evidence before he relies on the tape. Custody of tape records must be established beyond suspicion before a tape can be accepted. Section 65 of the Indian Evidence Act. State versus Entity of Delhi. State Entity of Delhi versus Navjot Sandhu, 2005. Criminal Law Journal 3950 of Supreme Court. This is a very important and a landmark judgment which talks about admissibility of called record, CDR record before the court of law. This judgment was a celebrated judgment, a landmark judgment. The attacks on the parliament, the accused were arrested and they were tried, and they were convicted, and against the conviction they filed an appeal. And during the appeal, one of the most important and the crucial point for consideration was admissibility of the call record. And one of the contention which was raised by the accused in that judgment was that the call records, which form part of the prosecution case, cannot be admissible, cannot be considered as an admissible piece of evidence because they were not accompanied by a certificate issued under Section 65B of the Indian Evidence Act. And this issue was elaborately discussed by the Honorable Supreme Court. And finally, the Honorable Supreme Court held in that case that even in the absence of a certificate under Section 65B, by virtue of Section 62, 63, and 64, the call records can be proved before the court of law by leading secondary evidence. This judgment was subsequently overruled by the Honorable Supreme Court in the case of Anwar versus K. Bashir. I will come to that judgment subsequently later during the course of my session. But before that, I would like to now come to the Information Technology Act, which deals with electronic evidence in a different perspective and a different and a technical angle, and how it has impacted the Indian Evidence Act, the kind of repercussions, the kind of consequences it has on the Indian Evidence Act. This is something which I would be dealing now. Almost all evidence is now created digitally, and what we mean by digital is anything that has been created or stored on a computer or a computer-like device, which includes data from satellites. Sources of electronic evidence include wide range of possibilities, including physical devices such as computers, mobile telephones, smartphones, PDAs, tablets, and such like components, including hardware, the processor, storage, software system, application software, the clock, time, span, storage media, and memory and data formats, networks such as internet, corporate internet, wireless networking, cellular network, and dial-up, and applications including email, instant messaging, computer to computer, and social networking. The Honorable Supreme Court has nicely held in the case of National Textile Workers Union versus C.R. Ramakrishnan, reported in AIR 1983, Supreme Court 75. The Honorable Supreme Court has recognized that if the law fails to respond to the needs of the changing society, either it will stifle the growth of the society and choke its progress. Law must therefore be constantly adapted to the speed of change in society and not lag behind. This was a brilliant observation of the Honorable Apex Court while dealing with the aspect of electronic evidence and the changes and the advancement in the technology, how technology has been seeping into the system before the judicial system, in the process of investigation, various other walks of life. Information Technology Act came to be enacted in the year 2000, and it amended the Indian Evidence Act, and it also had an impact on several other laws, existing laws in force in India, like the Indian Penal Code, the Bankers Evidence Act, and various other laws. Amending the Indian Evidence Act 1872 has made electronic records admissible as evidence in a court of law. Rules of evidence should not exclude an electronic record solely on the ground or because it is not in its original form. The IT Act recognizes electronic records as equivalent to paper records and provides for recognition of digital signatures. I will just cite a simple example pertaining to a law in the United Kingdom, England. Computer generated evidence requires a certification as to the authenticity of the evidence. For the certificate, either oral evidence can be called or a written certificate according to the Police and Criminal Evidence Act 1984 can be given. So the slightest difference over here is that in India, under the Indian Evidence Act, Section 65B, which has been incorporated in the Indian Evidence Act, that talks about how how an electronic record can be made admissible in a court of law. Section 65B says, notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof or production of the original as evidence of any content of the original or of any fact stated therein of which direct evidence would be admissible. Now, the conditions that are stipulated in clause 2 to section 65B are as under: A. The computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activity regularly carried on over that period by the person having lawful control over the use of the computer. B. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activity. C. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period, was not such as to affect the electronic record or the accuracy of its content. And D. The information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activity. Thus, these are the certain stipulations which required to be complied with or which are required to be in existence before any electronic record is considered or is made admissible in a court of law. Apart from this condition, section 65B also makes it mandatory for issuing a certificate, and that particular aspect is dealt with under clause 4 of section 65B. It reads as thus: in any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, A. Identifying the electronic record containing the statement and describing the manner in which it was produced. B. Giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, and C. Dealing with any of the matters to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate. And for that, and for the purposes of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. So, section 65B stipulates certain conditions and also talks about the requirement of a certificate. That's clause 4 of that particular provision. Now we come across many cases, criminal trials, in which evidence is adduced, electronic records are produced before the court of law, but the same is not accompanied by a relevant certificate under section 65B. These aspects have been discussed by the Honorable Supreme Court in the cases of State versus Navjot Sandhu and subsequently Anwar versus K. Bashir, which I would like to elaborate subsequently. But before that, I would like to just point out certain changes which the Information Technology Act has made in the Indian Evidence Act, certain things which has been incorporated under the Indian Evidence Act by amending the Indian Evidence Act. The term evidence, the definition of evidence, which is discussed under the Indian Evidence Act, under section 3 of the Evidence Act, the Information Technology Act adds section 3A to the Evidence Act, and evidence, and it states as under, evidence can be in oral or documentary form. The definition of documentary evidence has been amended to include all documents, including electronic records produced for inspection by the court. The term electronic record has been given the same meaning as that assigned to it under the IT Act, which provides for data, record, or data generated, image or sound stored, received, or sent in an electronic form, or microfilm, or computer generated microfiche. Now, admission under section 17 of the Indian Evidence Act has been changed and amended to include a statement in oral, documentary, or electronic form which suggests an inference to any fact at issue or of relevance. New section 22A has been inserted into the Evidence Act to provide for the relevancy of oral evidence regarding the contents of electronic records. It provides that oral admissions regarding the content of electronic records are not relevant unless the genuineness of the electronic records produced is in question. Thereafter, as I had already discussed before, section 65A and 65B have been inserted, which I have already read. Now, elaborating that aspect of section 65B2, conditions for the admissibility of digital evidence. Clause 2 of the particular section deals with these 4 conditions which are required to prove electronic records and make it admissible in a court of law. Now, there are several presumptions under the Indian Evidence Act which are covered by several provisions of the Act. The Information Technology Act has also made an impact to those kind of provisions and has made some changes to that effect. For example, a fact which is relevant and admissible may not have to be construed as a proved fact. The judge has to appreciate the fact to come to conclusion that it is a proved fact. The exception to this general rule is the existence of certain facts specified in the Evidence Act that could be presumed by the court. The Evidence Act has been amended to introduce various presumptions regarding digital evidence, and that I am explaining as follows. One, gazette, gazettes in electronic form. Under provisions of Section 81A of the Indian Evidence Act, the court presumes the genuineness of electronic records purporting to be the official gazette or an electronic record directed by any law, providing the electronic record is kept substantially in the form required by law and it is produced from proper custody. Second, the electronic agreement, Section 84A of the Indian Evidence Act, provides a presumption that a contract is concluded where the digital signatures of the parties are affixed to an electronic record that purports to be an agreement. Then, electronic messages. Under the provision of Section 88A, there is a presumption that an electronic message forwarded by the sender through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message fed into his computer for transmission. However, there is no presumption as to the person by whom such message was sent. This provision only presumes the authenticity of the electronic message and not the sender of the message. Similarly, electronic records which are 5 years old, as per Section 90A of the Indian Evidence Act, the provisions of Section 90A make it clear that when an electronic record is produced from any custody, which the court in a particular case considers proper, and it purports to be or is proved to be 5 years old, it may be presumed that the digital signature affixed to the document was affixed by the person whose signature it was or any person authorized by them on their behalf. An electronic record can be said to be in proper custody if it is in the place in which and under the care of the person with whom they naturally be. The Information Technology Act has also brought in some changes under the Indian Penal Code. For example, a number of offences were introduced by the provisions of the first schedule of the IT Act, and those provisions amended the Indian Penal Code with respect to certain offences for the production of documents that have been amended to include electronic records. The range of additional offences uh, includes absconding to avoid the production of a document or electronic record in a court under Section 172 of IPC, intentionally preventing the service of summons, notice, or proclamation to produce a document or electronic record in a court under Section 173 of IPC, intentionally omitting to produce or deliver up the document or electronic record to any public servant, that is under Section 175 of IPC, fabricating false evidence by making a false entry in an electronic record or making any electronic record containing a false statement, intending the false entry or statement to appear in evidence in judicial proceedings, squarely covered under Section 192 and 193 of IPC. Then, destruction of an electronic record, where a person secretes or destroys an electronic record or obliterates or renders ineligible the whole or part of electronic record with an intention of preventing the record from being produced as or used as evidence under Section 204 of IPC. And finally, making any false electronic record which is covered under Section 463 and 465 of IPC. So these are the changes that the IT Act has incorporated under the Indian Penal Code under various offences. Now I would like to discuss certain judgments of the Honorable Supreme Court and various High Courts which are particularly on the aspect of electronic evidence and the Information Technology Act. Because this being a very new branch of law, it is not developed to a major extent. So that's why we do not have so many judgments or so many guidelines on this particular aspect of law. Now we come across, now I'll explain certain aspects like evidence recorded on a CD, how it is admissible before a court of law. This particular aspect has been considered in the case of Jagdeep Singh versus State of Haryana, 2006, Volume 11, SCC, page number 1. In this, the Honorable Supreme Court, while hearing the matter, also considered the appreciation of digital evidence in the form of transcripts of digital media, including the Z News television channel, the Aaj Tak television channel, and the Haryana News of Punjab Today television channel. And after considering the entire discussion about the various aspects of law, the facts and circumstances, the court determined that the electronic evidence placed on the record was admissible and upheld the reliance placed by the speaker on the interviews recorded on the CDs for reaching the conclusion that the persons recorded on the CDs were the same as those taking action and their voices were identical. The Supreme Court found no infirmity in the reliance placed on digital evidence. Now coming to the intercepted telephonic calls and admissibility of intercepted telephonic calls. This particular aspect has been clearly discussed and elaborated by the Honorable Supreme Court in the case of State NCT of Delhi versus Navjot Sandhu, which was an appeal against conviction after the attack on Indian Parliament on 13 December 2001. In this case, it was also dealt with the proof and admissibility of the records of mobile telephone calls. While considering the appeal against the accused for attacking the Indian Parliament, a submission was made on behalf of the accused that no reliance could be placed on the mobile telephone call record because prosecution failed to produce the relevant certificate under Section 65B, Clause 4 of the Indian Evidence Act. The Supreme Court concluded that a cross-examination of the competent witness acquainted with the functioning of the computer during the relevant time and the manner in which the printouts of the call records were taken was sufficient to prove the call record. So even in the absence of a certificate under Section 65B, Clause 4 of the Indian Evidence Act, the Honorable Supreme Court held that the prosecution had proved the electronic records by examining the witness who was acquainted with the functioning of the computer during that relevant point of time. That witness was examined. He was even cross-examined during the time of trial, and that's how the printouts which were taken were produced in the court and were proved and were held to be as admissible piece of evidence. In the current scenario today, what happens is there are so many witnesses. Trials are so time consuming, and it's a Herculean task for the police to make present all the witnesses against whom summons are issued. And what we often encounter is uh, from the time of registration of the FIR and then subsequent filing of the charge sheet upon completion of the investigation, and then when the matter actually comes for trial, uh, sufficient time lapses between all these stages, and then it becomes very difficult to procure the presence of the witnesses. Some witnesses have, some witnesses are not available. Some witnesses cannot be brought in the court of law. Either they are settled abroad or it's not possible for them to come. In such a scenario, uh, instead of procuring the presence of the witness, the same can be also recorded. The evidence of the witness can also be recorded by way of video conferencing, which is another good advancement in the field of technology. Unfortunately, the same has not been majorly implemented in the judicial system across the country. Though in some cases they do try and they do try to implement these ways of examining witnesses by way of video conference. The question normally arises whether this is permissible in law. It is whenever any such application is moved before the court of law in order to dispense with the presence of the witness, often such application is met with strong opposition, and thus the court had an occasion to consider whether evidence can be recorded by way of video conferencing. And the Honorable Supreme Court, in the case of State of Maharashtra versus Dr. Praful B. Desai, has discussed this particular aspect. It involved the question as to whether a witness can be examined by means of a video conference. The Supreme Court observed that video conferencing is an advancement of science and technology which permits one to see, hear, and talk with someone far away with the same facility and ease as if they are physically present. The requirement of law for the presence of the witness does not mean actual physical presence. The court came to conclusion while allowing the examination of witness through video conferencing that there is no bar to the examination of a witness by video conferencing being essential part of the electronic method. This particular judgment has been further relied in another case of Amitabh Bagchi versus Anna Bagchi, in which the Calcutta High Court held that physical person physical person in court may not be required for purpose of adducing evidence, and the same can be done through medium like video conferencing. Section 65A and 65B provide provisions for evidences relating to electronic records and admissibility of electronic records, and the definition of electronic record includes video conferencing. So that's how it is permissible under the law. Further, the High Court of Andhra Pradesh, in one case, Bodala Murli Krishna versus Bodala Pratima, has held that necessary precautions should be taken to identify the witness and the accuracy of equipment used for the purpose of video conferencing, and the party who intends to avail themselves of the facility of video conferencing shall be under an obligation to meet the entire expense. There is another very important case which has laid down certain conditions before recording evidence by way of video conferencing. This case is 20th Century Fox Film Corporation versus NRI Film Production Associates Private Limited, AIR 2003, Karnataka High Court, 148. In this case, certain conditions have been laid for video recording. A. Before a witness is examined in terms of the audio-video link, witness is to file an affidavit or an undertaking duly verified before a notary or a judge that the person who is shown as the witness is the same person as who is going to depose on the screen. A copy is to be made available to the other side. B. The person who examines the witness on the screen is also to file an affidavit undertaking before examining the witness with a copy to the other side with regard to identification. The witness has to be examined during working hours of Indian courts. Oath to be administered through the media. Before examination of the witness, a set of plain written statements and other documents must be sent to the witness so that the witness has acquaintance with the documents, and an acknowledgement is to be filed before the court in this regard. The learned judge is to record such remarks as is material regarding the demeanor of the witness while on the screen. The learned judge must note the objections raised during recording of witness and to decide the same at the time of arguments. After recording the evidence, the same is to be sent to the witness and his signature is to be obtained in the presence of a notary, public, and thereafter it forms part of the record of the suit proceeding. The visual is to be recorded and the record would be at both ends. The witness also is to be alone at the time of visual conference and notary is to certify to this effect. The learned judge may also impose certain other conditions as are necessary in a given set of facts. The expenses and the arrangements are to be borne by the applicant who wants this facility. So these are the detailed conditions which have been laid down by the Karnataka High Court in this particular case. Now coming to CCTV footages. CCTV footages also today are very important and relevant because in most of the societies there are CCTV cameras installed at various places on the roads, on the highways. So CCTV footage can also become a very crucial piece of evidence, and the same cannot be dispensed with. In fact, in the celebrated case of the German bakery, it's called as a German bakery case, where during investigation, the police could track the accused only on the basis of the CCTV footage that was available. And the question in that case which arose was whether such a recording, which is neither on paper nor on a camera negative nor on a magnetic tape, in fact, not available in any tangible form at all, can be introduced in court as evidence. That was the only proof available uh, in that trial, and the trial court considered the CCTV footage while convicting the accused in that matter. Now, as I cited these two important cases, or there's one question over here. Okay, I'll come to those questions later after I complete my session. I'll address all the queries, whatever are raised. As I cited before, the case of State versus Navjot Sandhu of the Honorable Supreme Court. Now, this case had laid down a ratio, a proposition of law, which had a far-fetched effect on a lot of existing cases and trials. In that case, it was held in relation to electronic evidence. According to Section 63, secondary evidence means and includes, among other things, copies made from the original by mechanical processes, which in themselves ensure the accuracy of the copy and copies compared with such copies. Section 65 enables secondary evidence of the contents of a document to be adduced if the original is of such a nature as not to be easily movable. It is not in dispute that the information contained in the call record is stored in huge servers which cannot be easily moved and produced in the court. That is what the High Court has also observed in Para 276. Hence, printouts taken from the computer's servers by mechanical process and certified by a responsible official of the service providing company can be led in evidence through a witness who can identify the signatures of the certifying officer or otherwise speak of the fact based on his personal knowledge, irrespective of the compliance with the requirement of Section 65B, which is a provision dealing with admissibility of electronic records. There is no bar to adducing secondary evidence under the provisions of the Evidence Act, namely Section 63 and 65. It may be that the certificate containing the details in subsection 4 of Section 65B is not filed in the instant case, but that does not mean the secondary evidence cannot be given in the circumstances mentioned in the relevant provisions, namely Section 63 and 65. So the Honorable Supreme Court has relied on Section 63 and 65, and based on these two provisions, the Honorable Supreme Court has held that secondary evidence can be led in a court of law in order to prove and make electronic records admissible even in the absence of a certificate issued under Section 65B. Now, this judgment of the Honorable Supreme Court was subsequently considered in the case of Anwar versus Bashir. Now, this particular judgment, that is Anwar versus Bashir, it was a larger bench which had the occasion to deal with the law laid down by the Honorable Supreme Court in the case of State NCT Delhi versus Navjot Sandhu. And while discussing this particular case, it was held and observed by the Honorable Supreme Court. A. Copied data must be accompanied by authentication certificate. 9 years after it maintained that courts could admit electronic records such as printouts and CDs as prima facie evidence without authentication, the Supreme Court has said the view is wrong. Justice Kurian Joseph, writing the judgment on September 18 for a three-judge bench, including Chief Justice of India R.M. Lodha and Justice Rohinton Nariman, said the position taken by the court in its 2005 Parliament attack case verdict was legally incorrect. In its judgment in that case, a bench comprising Justices P.V. Reddy and P.P. Naulekar, while deciding on the admissibility of cell phone records of the accused, said the requirement of a certificate authenticated the electronic records could be given the go by. The prosecution relied extensively on such cell phone records in that case. It requires to be overruled. We do so. The judgment held, Justice Joseph wrote, it was pertinent for the Supreme Court to correct its position now, as there had been a revolution in the way evidence was being produced before court. So, how this advancement in technology and the usage of electronic records in a criminal trial had a major impact. The Honorable Supreme Court had to finally take a view that in order to ensure the quality of evidence in the form of electronic records, it is very essential to have a certificate under Section 65B which would authenticate the particular electronic record which is adduced in the court of law. Further, it was observed in the same case, tempered e-records can lead to travesty of justice. Supreme Court observed that electronic records are more susceptible to tampering, alteration, transposition, accession, and without proper safeguards, the whole trial based on proof of electronic records can lead to a travesty of justice. The three-judge bench was dismissing an appeal by P.V. Anwar, who lost the previous assembly election from the Ernaad constituency in Kerala to P.K. Bashir. MLA Mr. Anwar had contended that his opponent tarnished his image through character assassination using songs and CDs. Electronic records such as computer printouts, CDs, pen drives, microchips, VCDs, and so on are considered secondary evidence as they are copies taken from an electronic device that stores or processes the data. Section 65B, included in the Amended Evidence Act, requires the person in charge of the duplication of data to give the court a certificate that the data are authentic to the best of his or her knowledge. This specific provision overrules Sections 63 and 65 in the Evidence Act that did not insist on such a certificate, while reasoning that copying of electronic data is a mechanical process that does not allow tampering. The 2005 judgment in the Parliament attack case employed the same reasoning. Correcting it, the judgment held, thus, in the case of CD, VCD, chips, etc., the same shall be accompanied by the certificate in terms of Section 65B obtained at the time of taking the document, without which the secondary evidence pertaining to that electronic record is inadmissible. Thus, the final ratio of this judgment is very clear, and it has turned down and overruled the earlier view taken by the Supreme Court in the case of State NCT Delhi versus Navjot Singh Sandhu. And now the Honorable Supreme Court has, by way of this judgment of Anwar versus P.K. Bashir, has made it mandatory for a certificate under Section 65B, and without this certificate, the electronic record cannot be admissible in the court of law. Now, this issue, this particular ratio, this judgment has severe consequences to so many cases, the pending cases which are under trial, cases which are under investigation, and cases which are even at the appellate stage, where electronic evidence formed a major part in all these cases. So what happens is that there are several contingencies that can occur. For example, take a scenario where during investigation, certain electronic record is procured by the investigating officer, and at that point of time, he does not obtain the certificate as required under Section 65B during the time of investigation. This electronic record is further filed along with the charge sheet in the court of law. Now, during the time of evidence, during recording of this evidence, when this electronic record needs to be proved, what is the manner in which it can be proved? Can't the prosecution examine the particular witness who had procured those printouts from the computer device? Can't the prosecution examine him in the court of law and by examining him prove it in the court of law? As per the Supreme Court, it says that if there is no certificate, the document cannot be considered. But that can have some consequences, and that can even lead towards discarding of certain evidence which is very crucial and which will ultimately allow and help the accused to go scot free, because there are cases which can rest solely on the basis of electronic evidence, and there is a possibility that at the time when this evidence was collected, the certificate was not taken under 65B. Does that mean that we just discard this entire evidence and the accused goes scot free? All these issues also created a lot of speculations, and there are so many other cases which subsequently came which discussed on this particular aspect, on whether in the absence of certificate under Section 65B, what would be the fate of such evidence, such electronic records. One such judgment which subsequently had an occasion to deal with this aspect was of the Honorable Supreme Court in the year 2019, M.R. Hiremat versus State of Maharashtra. In this judgment, what the Honorable Supreme Court held while discussing the ratio laid down by Anwar versus K. Bashir, and even by considering several other judgments, past previous judgments of the Honorable Supreme Court, the bench held that this particular defect of non-procurement of certificate under 65B is not fatal to the case of prosecution, and it is at the most a curable defect. So, as per that judgment of the Supreme Court, it allows procurement of that certificate and filing that certificate even subsequently during the time of trial. But there are several issues which deserve to be considered, which I feel have not been considered in so many cases by the Honorable Supreme Court and by the High Court also, because every case has their own facts and circumstances, and the courts will, after all, appreciate the facts and circumstances which are there in front of them, and then we would go on to pass certain rulings and findings on the particular aspects of law. But there are situations where uh, there is nothing clear as regards whether that certificate, though the court say that the certificate can be filed in the court of law at a later point of time, there is nothing specifically stated as regards when that certificate has to be obtained. Can a person prepare such a certificate at a subsequent stage during the time of trial, stating that he was the one who was operating that particular computer device, and that computer device was in operation and was being regularly used for feeding data, for transmitting data, and during its operation he had procured those printouts from that computer? If can such a certificate be made and issued at a later point of time? These aspects are yet to be considered, and there are no such direct guidelines on this particular aspect, which discuss on the aspect of admissibility of electronic records in view of the provisions under Section 65B. Now there are certain other aspects also, which the Information Technology Act and the uh, admissibility of these electronic records have brought some changes in the regular existing provisions of various laws. For example, under Section 138 of the Negotiable Instruments Act, there is always a requirement of sending a statutory notice after the dishonor of the check. Now, can this statutory notice be sent by way of an email is something which was discussed by the Honorable Supreme Court in the case of Messrs. Still Import USA versus Messrs. Exim Aid Still Exporters, 1999 AIR Supreme Court. Uh, the issue before this case, in this case, was whether a fax notice can be considered as a note, statutory notice, whether a statutory notice under 138 can be sent by way of a fax message. And what the court held was very interesting in this. When the legislature contemplated that notice in writing should be given to the drawer of the check, the legislature must be presumed to have been aware of the modern devices and equipment already in vogue and also in store for the future. If the court were to interpret the word giving notice in writing in the section as restricted to the customary mode of sending notice through postal service or restricted to customary mode of sending notice through postal service or even by personal delivery, the interpretative process will fail to cope up with the change of time. It was held that if the notice envisaged in clause B of the proviso to section 138 was transmitted by fax, it would be compliant with the legal requirement. The requirement of a written notice under Indian law is satisfied if the same is given in the form of a facsimile, transmission, or email. The notice by email can be sent instantaneously and its delivery is assured and acknowledged by a report showing the due delivery of the same to the recipient. The method is more safe, accurate, economical, and quick than its traditional counterpart, popularly known as registered post acknowledgement due. Since September 2006, the Indian government has made it compulsory that all the statutory filings under the Indian Companies Act 1956 would be in electronic form only, which has to be authenticated by the use of a digital signature. Now, there are several other interesting cases also which I would like to just discuss in brief. There's this case, this is a very interesting case, Dharamveer versus CBI. It's a case of the Delhi High Court in which certain data, call records, were copied from hard disk to a CD. Cyber Forensic Lab in Hyderabad confirmed that the recorded data on CD were true copies of the original and that the hard disk was in working condition. A question came: difference between electronic device and electronic record. It was held that if the electronic device has ever recorded any data which is relevant for a case, such electronic device shall be treated as electronic record for the purpose of evidence. There is another important case which I would like to just explain and narrate because one of my friend was also involved in that case, and that finally led to declaring Section 66A of the Information Technology Act as unconstitutional. It was a famous case of Shreya Singhal versus Union of India. In that case, what had happened was two girls were arrested, and their arrest had shocked the whole nation, where they have been arrested for their Facebook act, which questioned the shutdown of city on the demise of Shri Balasaheb Thackeray. Not only this, Several arrests have been made under 66A, which include the arrest of a professor from Jadavpur University for his alleged circulation of caricature about TMC boss Mamata Banerjee, and a businessman from Pondicherry who tweeted about a son of a former union minister. So, in the light of series of arrests made under Section 66A of the Information Technology Act 2000, a writ petition was filed in public interest under Article 32 of the Constitution of India by a law student seeking to strike down Section 66A as unconstitutional on the ground that the phraseology of Section 66A of the IT Act 2000 is so wide and vague and incapable of being judged on objective standards that it is susceptible to wanton abuse and hence falls fold to Article 14, 19, 1A and Article 21 of the Constitution. He further contended that the terms offensive, menacing, annoyance, inconvenience, danger, obstruction, and insult have not been defined in the IT Act, General Clauses Act, or any other legislation, and so they are susceptible to wanton abuse. He further urged that the provision sets out an unreasonable classification between citizens on one hand and netizens on the other hand, as the freedom generally guaranteed under Article 19(1)(a) to citizens, including general media, now is curbed as far as netizens are concerned. If netizens make comments which could be generally made by citizens, they can be arrested. This is how Article 14 is being violated by this provision. He also submitted that unless there is judicial sanction as a prerequisite to the setting into motion the criminal law with respect to freedom of speech and expression, the law as it stands is highly susceptible to abuse and for muzzling free speech in the country. Thus, by making such observations, the Honorable Supreme Court concluded that Section 66A was unconstitutional as it was drafted so widely that it could cover virtually any opinion on any subject that dissented with the mores of the day. Moreover, the provision was widely drafted so as to include information of scientific, literary, or artistic value. It was therefore unconstitutional as it could be used in such a way as to chill free speech and expression. Moreover, the provision could not be saved by the assurances from the Additional Solicitor General that it would be administered in a reasonable manner. So, with this, I would like to conclude my session. I hope I have covered quite a few aspects and cleared some doubts about this, explained certain aspects and tenets of the Indian Evidence Act and its repercussions, its consequences, the impact that it has towards various other acts, towards various cases, and how this technology is in fact making certain changes and amends to the provisions of law and to the procedures. Yeah, Rishikesh, you can
Yeah,
please.
Madhukar, one of the questions has come from one of our participants, Mr. Uma
Yes,
Shankar. The
yes,
question is that what is the basic difference between the normal evidence what we tender versus the
hmm,
digital evidence? For example, when normal in a court process we are trying to tender any evidence or a document, we have to get it notarized. So if
no,
any,
okay. I'll come to this. See, as before I started my session, I first dealt with certain provisions of the Indian Evidence Act. What a document is, what evidence is, as defined under the Indian Evidence Act. Section 3 defines the document, and Section 3 also defines the term evidence. So basically, what happens is there are two ways of proving a document, either by way of primary evidence and by secondary evidence. Primary evidence is by producing that document itself in its original form. When the document is not available in its original form, then there are ways of uh, adducing secondary evidence as stipulated and explained under Section 65 of the Indian Evidence Act. Now, electronic record is basically something which is new and which has been incorporated by the Information Technology Act only with a view of making it admissible in evidence. And to make it admissible in evidence, like for example, there is, say, you take some printouts from the computer, or you have a transcript of a WhatsApp chat or various other messages, and now you cannot produce. How will you produce? How will you prove those particular conversations? You can't produce the entire computer or the entire CPU in the code. So the other alternative is you get the printouts. Now these printouts that you get, that you procure, they are not in original form. They are in the form of like a photocopy of it. You are making a copy of it. Now this copy, which is otherwise, which would have been inadmissible in evidence, can be made admissible by leading secondary evidence, and that is done by virtue of section 65B of the Indian Evidence Act.
I think nicely you have summed up that query. Second query, Madhukar, is how this digital evidence gets affected when any of the person who is very instrumental to the whole process of evidence, there is a death of that person, or there is some incapacity like a coma or something. Again,
Okay.
there can be two kinds of scenario. One, before the giving of the certificate, because the way I have understood, as per the latest judgment of the Supreme Court, that certificate is mandatory
Yes.
for an evidence to be standing in the court of law, right?
Yes.
So
Yes.
if there is a death of a person or incapacity, then what would happen? Or the other way around, he has given that certificate, but he is no longer there. You cannot cross-examination.
See, take a simple case. Let's leave aside this Information Technology Act, leave aside this electronic records, admissibility of this electronic evidence and all. Take a normal criminal case. In a normal criminal case, there is an eyewitness. Eyewitness, he gives a statement. His statement is recorded by the police and is filed in the court along with the charge sheet. Okay. Now, this statement, which is recorded before the police officer, is not admissible in law. Now, in order to prove that, the prosecution has to bring that witness in the court of law and examine him, give an opportunity to the accused to cross-examine that witness, and that's how his evidence can be considered before a court of law. Now, if that person dies at the time of trial, what is the impact on the trial? The court has to go by whatever other evidence is adduced by the prosecution. Sometimes, even if a crucial witness is unavailable during the time of trial, his presence cannot be procured, that does not mean that the court can directly discard the other case of the prosecution and acquit the accused. Court can still convict the accused if there are other circumstances which can link the guilt of the accused. Similarly, in this case also, suppose there is a certificate. Now, the requirement of certificate is a very important aspect to understand. The first condition is the requirement of certificate, because the requirement of certificate, the certificate will allow you to lead secondary evidence. Now, if that certificate is not there, you cannot lead secondary evidence. The certificate is not like a complete proof of the electronic record. Certificate does not prove the truth and the correctness of the electronic record. Certificate merely gives you an opportunity to lead secondary evidence. Now, how do you lead secondary evidence to prove the electronic record? And that is by examining that witness who has issued that certificate. When the prosecution will put that witness in the box and examine that witness, and the accused gets the chance to cross-examine that witness, then only that electronic record will be admissible. And then it is for the court to decide how much weightage to give to that particular piece of evidence.
So in other words, it's something like a self-certification. A person who wishes to rely on a particular document or a particular witness, that particular A person has to get it signed and affidavit by way of an affidavit, and he has to file it in the court.
It's like without a driving license, you cannot drive a car.
Right.
Similarly, without the certificate, you cannot lead secondary evidence. And electronic record is not primary evidence. Electronic record cannot be considered and proved by way of a primary evidence.
I think you have very well summed it up, because I think it's not such an easy topic, but the manner in which, the flow in which you have led the participants through this sensitive and very crucial topic, I think it's only a person with a hands-on experience can do it, because it's not only in one act we are dealing with, because CRPC comes into place, if I'm not mistaken, IPC is there, information technology is still an evolution law in our country, and the Indian Evidence Act, the most crucial part comes in. And definitely, as part of the litigation, I am very sure the we lawyers are also trying to bring the angle of the Constitution and all that also in place. So we are talking about 4 to 5 different pieces of legislation.
Yes, Rishikesh.
So I would now like to offer my vote of thanks to Advocate Madhukar Dalvi. On behalf of Udan Saluters, we thank you for devoting your precious time, and I'm very sure in future also you would love to share your knowledge like what you have done today. And I will also take this opportunity to inform our participants that this entire week we are going to do a series of webinar. Very soon we'll be disclosing it, from the topic of insolvency laws, the recent government orders on the payment, mandatory payment of wages and the salary, whether what is the validity and what are the challenges, and also the operation mismanagement and the minority share are some of the only few topics what I have disclosed.